Good morning and welcome to Law Talks here on 4CRB. Well, dementia is something many Australian families are facing as our population ages. Although it can happen to anyone, it becomes far more common after the age of 65. According to Dementia Australia, it's now one of the leading causes of death in the country, and more than 446,000 Australians are currently living with the condition. But one of the most misunderstood aspects of dementia is the question of legal capacity. When does someone lose the ability to make decisions about their finances or legal affairs? You may remember the tragic death of actor Robyn Williams in 2014. After his passing, it was revealed he had been suffering from Lewy body dementia, a condition that had initially been misdiagnosed as Parkinson's disease. Situations like this highlight just how complex neurological conditions can be and raise important questions about how cognitive declines affects decision making and why planning ahead is so important. And joining us again today is Attwood Marshall Lawyers Legal Practice Director Jeff Garrett. Thanks for joining us this morning, Jeff.
Thanks, Robyn. Thanks for having me.
Well, Jeff, dementia is something many families are increasingly dealing with. From a legal perspective, why does it create such complex issues?
Yes, it's an ever-increasing area of legal issues coming out of it because previously it was a bit rarer than what it is now. And almost in every family you hear stories of people suffering from some form of dementia. And it impacts just about every part of our lives, including the legal issues that can crop up from time to time that we all face. And previously, I think that there weren't as many people doing their wills and having enduring powers of attorney and other documents made. And there was far less, I think, knowledge about these things. So, and I suppose one of the biggest myths out there at the moment is that, well, if you're diagnosed with the onset of dementia, that's it.
Yeah.
You can't make a will. You can't sign an enduring power of attorney. Can't even get married. Or enter into any sort of contract or anything like that. And I suppose that's one of the biggest earthies, because that's not the case. You can have dementia. You can have the onset of it. It just depends on how far advanced that is and what your cognitive functioning is like for you to be able to, for instance, give instructions and sign a will, or to give instructions for the preparation of an enduring power of attorney and sign it. And there are differing tests for the documents and the decisions. So, for instance, the level of capacity that you need to get married is a lot less than it is to give instructions and make a will. Making a will is a lower standard than making an enduring power of attorney, believe it or not. So legally you have all of these different tests and levels, and then you superimpose the dementia and types of dementia that you can suffer from, and then try and work out, okay, well, if you're making a will, do you have the testamentary capacity required to understand your estate and provide instructions to a lawyer and prepare a will and sign it? And that's why the Robyn Williams example is so interesting, because it's yet another type of dementia that most people would never have heard of. Lewy body dementia. His own family didn't know about that. They only found out that he had it after he died, when an autopsy was done. So getting back to what I said about there being so many types of these conditions and dementia, it really is a complex situation out there when you're trying to determine whether someone has the requisite testamentary capacity to provide instructions and have, for instance, a will done on their behalf and signed.
So, Jeff, in legal terms, how do courts determine whether someone has the capacity to make important documents like a will or an enduring power of attorney?
Yeah, well, both of those have slightly different tests that are applied to them. But the test of testamentary capacity, believe it or not, is a decision that can only be made by the courts. You would think that doctors are the ones that would be the ones who make that decision. And they certainly help the courts determining whether someone has capacity. But it is more of a legal issue, and that capacity test, it's fairly general, but it really means that whoever it is that's, let's say, making a will, because that's probably the most common that comes up, the test is that they understand the type of document that they're providing instructions for. They understand the assets that are in their estate. They understand who their beneficiaries are and how how their assets are to be distributed, and that, what's the fairest thing to do between those beneficiaries or charities or whoever it is that they're to leave them to. And the test about whether they have the requisite capacity to understand those issues, that's a really difficult thing sometimes. And one of the issues that often crops up is that people have fluctuating types of capacity. So you've heard, some people are better in the morning. Some people are better in the evening. And we've had cases where clients have fluctuated so much that we had to get a geriatrician to confirm that they had the requisite capacity at the time of the interview when we took instructions for a will, to make sure that they were okay. And there's the legal test is quite difficult sometimes in determining whether someone passes the test. And this has been around for a long time. And there was a famous House of Lords case which deals with this back in the 1850s. I love this case and where it comes from, but there was an 1857 case of Boyce and Rossborough in the House of Lords, and they were describing, how do you determine whether someone has the requisite capacity, and they likened it, or the Chief Justice in that case likened it to twilight. And his statement is a classic, and I'll read it to you. There is no possibility of mistaking midnight for noon, but at what precise moment twilight becomes darkness is hard to determine. And he was making the analogy with...
It's a great analogy.
Assessing it. And I thought, back in 1857, what a great statement.
Yeah. Yeah. So, Jeff, does that mean someone living with dementia may still have the legal capacity to do those important things like make a will or appoint an attorney, sell assets, or even get married?
Yes, they can. It just depends on the type of condition that they're suffering from, that, they may well have sufficient periods of lucidity in their condition where they can do that. And you just got to be really careful in who you see about those things. And that includes not only the doctors that you're using, because generally a general practitioner, this is beyond that. You really need to deal with geriatricians and specialists in this area. But by the same token, you also need to use lawyers who are experienced in this area and know what they're doing.
So, Jeff, because capacity can change over time, why is early planning so important for families?
Well, getting back to all of those complex issues concerning dementia and whether someone has the capacity to do this, if you get in nice and early before any of this happens, then those documents are sound. And the other thing about modern conditions, one of the biggest issues is the early onset of dementia. So you have people now in their late 30s, in their 40s, who have they call it early onset of dementia. Just seems to go with our lifestyle and all the things that are affecting our bodies these days. But so you can't wait. If you leave it too long, then it could be that at the time you go in to get something done, you don't have the requisite capacity to do a will or an enduring power of attorney. And that's when you've got to call in or go to the tribunals to have people appointed to act on your behalf. And, you've got the public trust involved. Sometimes it's just a nightmare. So you're better off to get in nice and early, see an estate planning lawyer who knows what they're doing, and get your will, enduring power of attorney, and if needs be, an advance health directive. Get all that done before the onset of dementia.
And Jeff, one of the most important decisions people make when planning ahead is who do we appoint to act for them if they do lose capacity. So what should people consider when choosing an attorney under an enduring power of attorney?
Yes, great question. And one of the most important things, and it's often overlooked, you really need to be able to trust implicitly the person or persons that you are appointing. And sometimes appointing family members doesn't cut the mustard. You can't trust them. And in a lot of the cases, the family members, even children, adult children, are the ones who breach the trust in relation to handling their parents' financial affairs after they've lost capacity. So sometimes you might have to look at appointing someone who is independent and perhaps a professional, that is a lawyer, accountant, whatever.
So Jeff, as you say, some people worry about appointing family members or they're just not up to the task. And it may cause potential for conflict or even misuse of power. Have you seen situations where appointing the wrong person as an attorney has gone horribly wrong?
Oh yeah, all the time. It happens so much that it's sickening, really. But yeah, the incidence of financial elder abuse is so high and so prevalent now that it's rare that we don't get a case where an elderly parent's finances have been abused by adult children.
Mm. And finally, Jeff, for listeners who may be starting to see signs of cognitive decline in a loved one, what steps should families take to make sure legal planning is put in place before capacity does become an issue?
Yeah, well, one of the first things is to go and get some advice from an experienced estate planning lawyer. And sometimes you may need to consult with the GP and or the geriatrician to give them a certificate of capacity where they will confirm that they have the required capacity to give instructions for a will.
All right, well, that's all we have time for today on Law Talks. Jeff, these are often difficult conversations to have, but they are some of the most important, and putting plans in place early can make all the difference when it matters most. Thanks for joining us today.
Thanks, Robyn.
You've been listening to Law Talks here on 4CRB, which you can hear every Friday morning from 9 o'clock.